a reputed media broadcasting house.
Eve or evening are two different things.
Evening. It's evening. Being ABP Anando for interviewing the panel. To the utter shock and surprise, the petitioner's son was suddenly detained by the Moidan police station from the outside of the media broadcasting house and were taken into custody by the concerned police authorities illegally and arbitrarily in connection with Moidan police station case number so and so. Now, my lord, your lordship will find from para 12, there are other two cases on the next day we have found. My lord, other two cases also where the petitioner's son named in the FIR. Now my prayer is this before your lordship. The peaceful protest was allowed by the Honorable Supreme Court as well as our High Court. The petitioner was, my lord, participating in a peaceful procession. Now, the petitioner's son, he was not arrested on the spot. If anything was found that he has, my lord, hit any of the police personnel or done anything which is not lawful.
Sections that I mentioned, what does it say?
My lord, only one section your lordship will find, that is 109. My lord, kindly marked it. My lord, as others are, my lord, unlawful 147, 148, which is less than 7 years. Only one section, 109, your lordship will find, this is attempt to murder.
Okay.
This is 10 years or up to life. So, no notice, in terms of the new act, section 35(2) is not, my lord, applicable only because of this section. And only this section has been given by the police. Only to, my lord, curtail the personal liberty of the petitioner's son. Otherwise, my lord, they should have, if they wanted to arrest me, they should have provided me, my lord, the 35P notice. That was only to overcome that, my lord. They have incorporated these sections. And, my lord, if I have done anything, my lord, there are almost 10,000 police personnel are there. And they have protected the unruly mob also. As per them, as per their, my lord, although 144 was not there all over the cities. The 144 was there in and around of Nabarno. But the protest was stopped near the AJC flyover, near this Eden Garden, where the police has cordon, they have made a cordon so that the procession cannot go to the second Hooghly bridge. So they are stopped there. Some commotion because police has, they have used water cannon, they have used, the tear gas, and severe lathi charge was there. Number of person was injured. The petitioner's son was not arrested from the spot. He was, joining a peaceful procession. In the evening, when he went to a reputed media house for the panel discussion, when he was coming out, he was arrested on the basis of the FIR. These 3 FIR we have challenged before your lordship, and we also, prayed for any other cases has been, registered against the petitioner's son. Let them apprise your lordship's court, and in the meantime, give us interim bail till they file their affidavit in opposition. Because this is clear violation of the Honorable Supreme Court's order, and there is not a single evidence where the petitioner has assaulted someone or he, the attempt of murder can be legal against him. Let them show one single evidence. The petitioner's son has participated for attempt to murder. And kindly see where I have been booked. The allegation they have given 120. Kindly come to 120. Kindly come to 120. How these police persons they are acting, your lordship will understand. Yes. They are more concerned to protect the flags of the other political party rather than doing their own duties. Kindly see it once. This is to inform you that on 27/8/2024, this is a suo motu complaint call 120, 120. Kindly come to 120. How they are acting, your lordship will understand everything. What is their actual motive, your lordship will understand from this FIR. This is a suo motu complaint. This is your for kind information that on 27/8/2024, near about so and so hours, information received from anonymous telephone caller that some agitators assembled JL Nehru Road, so and so crossing and being showing their agitation. Accordingly, the undersigned, along with the available force, including the lady force, reported to JL Nehru crossing and commonly known as Dorina crossing and found 150 agitators, including the ladies, under the banner of Paschim Bongo Chhatra Samaj, where I have been make as a leader of this group, called for Navanno Abhijan by Probir Das, Sayan Lahiri, Sayan Lahiri is my son, and Shubhankar Haldar, unlawfully assembled there by blocking the Jail Nehru Road without any permission of concerned authority, with caused disruption of normal vehicle and pedestrian movement. They raised slogan by shouting over the issue ongoing Arjikar hospital matter. Is this a crime? I am asking myself. Then the next matter. Then they were too violent mode, and they were repeatedly appealed not to break the law and order situation and do peaceful protest, but all of these requests fell in deaf ears. Meanwhile, some agitators became agitated. Also damaged some flexes of TMC party, which affixed at a different places in around of the vicinity of the spot. But this is the actual duty of the Kolkata police is doing. After that, they were again repeatedly requested not to do such type.
Very well. Is this the complaint?
One of the complaint where I have been arrested.
Complaints. The case number must be there.
Yes, my lord. It is case number. Your lordship will find the 199. It is, my lord, FIR number 114, dated 27/8/2029. This is New Market Police Station.
Yes.
My name is there.
Your name is there, and
Yes.
you have been arrested in connection with
Not
this case?
not yet.
Not yet.
Not yet. Because their whole intention is this. They have arrested me in connection with the Moidan police station case.
Where is that FIR?
Well, we could not collect, the petitioner's mother could not collect that. But he got the information. These are the 3 cases where his son has been arrested. Now, my lord, other 2 cases where, my lord, I am praying for quashing along with this FIR, your lordship will find not a single allegation, so far as all are suo motu complaint. Not a single allegation against the petitioner's son. He actually attempt to commit murder of someone. And if person, they will say that one police personnel, now it is widely circulated in the media that one police personnel, one person has thrown brick bats and he injured with his eyes. Now they are showing all over the media. Whether, so far as this act is concerned, whoever has done it, let him face the consequences. The petitioner's son, whether he has done this act or not, kindly consider that also. And whether this is their case, his son has thrown this brick bat. And kindly visualize the situation once. The protest rally was going on. At least 5,000 to 6,000 police personnel, they were blocking them from everywhere from the city. Water cannon was used. Tear gas was charged. Some of the participant of the mob, they maybe became violent and do certain acts. Whether the petitioner will be responsible for that or not, that is the whole question. And whether the detention of the petitioner is anymore is required or not. Admittedly, he is a student. He is completed his MBA in the year 2023. We have annexed all the document. And your lordship, I shall place one judgment of the Honorable Supreme Court to which says the role of the court when there is a police access.
Para 67. আচ্ছা তার আগে একটু প্যারাগ্রাফ চাকরিটা প্লেস করে তারপর রাত্রিরে বেশ ফরওয়ার্ডটা ওটা পড়া পড়ছে।
Kindly turn to para 67. Whether sitting in a 482 jurisdiction or 226
Mr. Mojumdar, if you could kindly give the citation.
Shraddha Arnab Goswami, you know better than me. You have read this more than I read.
Yes. Arnab Goswami.
Para 67.
Yes.
Human liberty and role of courts. Human liberty is a precious constitutional value which is undoubtedly subject to regulation by validate enacted legislation. As such, the citizen is subject to the edicts of criminal law and procedure. Section 482 recognizes the inherent power of the High Court to make such an order necessary to give effect the provision of CRPC or to prevent the abuse process of law and otherwise to secure the ends of justice. Decision of this court required the High Court in exercising jurisdiction under Section 482 to act with circumspection. In emphasizing the High Courts must exercise this power with a sense of restraint, the decision of this court are found on the basis of principle that due enforcement of criminal law should not be obstructed by the accused taking recourse of artifacts and strategies. The public interest of ensuring that due investigation of the criminal protect the ensuring the inherent power of the High Court is exercised with caution. It is indeed one of the safeguard end to the spectrum. The other spectrum is equally very important. The recognition, section 482, the power inherited by the High Court to prevent the abuse of process to secure the end of justice in a value safeguard in the protecting liberty. The Code of Procedure 1998 was enacted by the legislature, which is not subject to the constitutional right and limitation. Yet it recognized the inherited power under section so and so post-independence. The recognition by the Parliament of the inherited power of the High Court must be constructed with an aid of to preserve the constitutional value and liberty. The writ of liberty runs through the fabric of the Constitution. The need to ensure the fair investigation of a crime is undoubtedly important in itself because it protects at one level the rights of the victim and the more fundamental level the societal interest in ensuring that a crime is investigated and dealt with in accordance with law. On the other hand, it is important. The misuse of criminal law is a matter of which the High Court and the lower courts of the country must be alive. In the present case, the High Court could not have been cognizant of the specific ground which was raised before it by the appellant. He was made a target as per the purpose of serious consequence for which is taking place in April so and so. The specific cause of the appellant, he has been targeted because the opinion of the television channel authority. However, the appellant entrusted for the case quashing of the FIR at the High Court to take final view on the proceeding are listed so and so, the FIR and the High Court. The court, the sentence started with the court. The courts must be alive to do the safeguard of the public interest in ensuring that due enforcement of criminal law is not obstructed. The fair investigation of a crime is aid to it. Equally, it is duty of courts across the spectrum, the district judiciary, the high courts and Supreme Court, to ensure that the criminal law does not become a weapon of selective harassment of citizens. Courts should be alive to both ends of spectrum. We need to ensure that the proper enforcement of criminal law on the one hand and the need on the other end of ensuring that a law does not become rush of targeted harassment. Liberty across the human era is tenuous and tenuous can be. Liberty survives by the vigilance of citizens and the company of the media and the dusty corridors of the courts alive to rule of law. Yet so as often liberty's casualty when this component is found warranting. Mr. Sibal, Mr. Desai and so and so are undoubtedly right. Submitting the procedural matter, it is very important. Hierarchy of the court is matter of concerning the grant of bail needs to be respected. However, there was a failure to the High Court of discharge its adjudicatory function in two levels. First, decline the evaluating the prima facie of the interim stage in a petition for quashing of the FIR as to a arguable case has been made out. And secondly, in declining interim bail as a consequence, its failure to render a prima facie opinion at the first time. The High Court did not have the power to protect citizens by an interim order to in the petition invoking 226. Where the High Court failed to do so, this court would be abdicating its role and functioning in a constitutional court if it refused to interfere despite of the parameters of the interfering being made. The doors of the courts cannot be closed to a citizen who is able to establish a prima facie that the instrumentally of the state is being weaponized for using criminal force in law. Our court must be ensured there are continue of remain of the first line of the defense against the deprivation of liberty of a citizen. Deprivation of the liberty of a citizen for a single day is one day is too many. We must always be mindful of the deeper systematic implications of our decisions. So, my lord, my case squarely falls within these parameters of this judgment of the Honorable Supreme Court delivered in 2021 by Mailasis Chandrachud and Mailasis Banerjee.
Yes.
Yes. Now, Milord, 64 on the same judgment, kindly come, Milord. What are the parameters when your lordship will grant bail in a 226 application? While considering an application for grant of bail under Article 226 in a suitable case, the High Court must consider the settled factors which emerges from the precedents of this court. These factors can be summarized as follows. The nature of alleged offense and nature of acquisition and severity punishment of this case of conviction. This is number one. Second, where this exercises reasonable apprehension of the accused tampering with the witness or being threatened the complainant or the witness. In our cases, all are police witnesses. Third, the possibility of securing out the presence of the accused at the trial or likely to the accused of fleeing away from justice. But so far as my son's case is concerned, it doesn't apply. Four, the antecedent and circumstances which are peculiar to the accused. In our case, my son has no antecedent. 5. Whether prima facie ingredients of the offence are made out on the basis of the allegation as stated in the FIR. That's why I told you, Lordship, let them show from one FIR, my son has participated for assault of some police personals. Let them show. All are suo motu complaint. It is not that some unknown person is lodging the FIR. The police themselves is lodging the FIR. And in the FIR, my son's role doesn't transfer for involvement of a commission of offence under section 109, which is the old code of 307. The significant interest of public and the state and other similar considerations. In our case, the public was protesting, the student wing was protesting, and joined by other the wings of the public. And this was a protest rally, peaceful protest rally. Because of them, it became unruly. Because they started water cannon, they have started lathi charge, they have started using tear gases. So some of the protesters became agitated and done some acts. Whether I can be responsible for that or not, this is the whole question before your Lordship.
Senior judgment the coordinate bench because senior order.
Now, one judgment which I have handed over before your Lordship, because Singh,
Coordinate bench.
the coordinate bench order, where in a 226 application, the High Court rightly said that this in ordinary cases the remedy before the 437 or 439, but in exceptional circumstances, the writ court is the only the protector. Here, the Arnab Goswami was considered, and kindly see para 3. I entertained this writ petition keeping the question of mentability as raised by the court open. However, having to the period of detention already undergone, I am inclined to consider the prayer for bail. So ultimately, the prayer was allowed. And 3, your Lordship will find from the second para, the submission of the learned Advocate General, his writ jurisdiction would not be involved with the rare and exceptional cases. So his case also, in rare and exceptional cases, the 226 jurisdiction can enlarge a person's to protect the personal liberty. So, today the question before your Lordship is this: whether my custody is required or not, and the parameters which is given by the Honorable Supreme Court, I am following on the parameters. I am a student. My son is a student. Under any terms and condition, let them file opposition. In the meantime, your Lordship can release me on interim bail. And other 3 cases, I may be protected.
And list of cases
and a list of cases may be given to us.
Before the learned Advocate General starts on facts, because it's not for us to easy to communicate. If you like, I have sought his leave, permission on that. From the first things that were submitted, that after the incident, may I just take one? After the incident, the seminar room where the incident happened was vandalized, and that no step was taken. I could not take.
No, it's no use making submission on that, because.
So I just, because all these were addressed one after the other.
No, the court is not concerned whether it was vandalized, not vandalized. Steps are being taken by different fora.
So, may I just say that this was I have pictures that it is fully safe. The next thing.
What you have got against the petitioner?
Yes. May I say this first thing first? Submissions were made that this was a very peaceful rally. May the Lord should kindly see how peaceful was this rally. These are from the Strand Road.
No, but you have to show that the petitioner was responsible for this.
Yes. So, today, if he was one of those who led this rally,
yes,
he's an FIR named accused.
Yes.
Over here.
Right.
So he has to if today an incident happens, can he avoid the responsibility of this whole thing? Today I lead a rally, and may I say this, there are specific statements made by him which were extremely provocative. He made a press conference the day before and said, I will not take permission. He said, I'm going to take out 2 processions. He took out 5. So he was the one who was misleading everybody. He was the one who was leading it. And the Lord should kindly consider one thing. Can I today call for a rally meeting, procession, and say that I will not be responsible for anything that will happen in that rally? He was specifically intimated that please let us know where do you want to do, how many people were, letters were written to him. His name is number 3 over here. We were sought for details. He said his basic statement in the press conference, I will not give any details. After that, can he say that he will not take any responsibility? On the factual score, these are things which the learned advocate general could not have handed over to your lordship. Please, order.
Yes.
If the Supreme Court order was placed at length, my lord, I'll place that. Mr. Banerjee,